Welcome. I'm Daniel Jacobson. I'm a professor of philosophy at CU Boulder and director of the Benson Center for the Study of Western Civilization. Our mission is to promote the study of Western civilization and to increase intellectual and political diversity on campus. Tonight's talk is generously sponsored by the George Mason University Law School's Voices for Liberty project. And it's my pleasure to, can't hear? Tonight's talk is sponsored by the George Mason Voices for Liberty project, and we thank them. It's also my pleasure to welcome back last term's visiting scholar in conservative thought and policy from George Mason University, Professor Todd Zywicki, who will introduce tonight's speaker.
Thanks, Dan. It's great to be back, and hopefully we'll be watching the Buffs in the March Madness if they get in like they belong. But it's great to be back, and I feel like I've traveled 1,500 miles to now participate in the George Mason program. But it's a real thrill for us to have Eugene with us today. I was trying to remember, Eugene and I've probably known each other for 30 years, something like that. But Eugene's a little bit, so we kind of came up in this business together, but Eugene's a little bit younger than me because he graduated from college when he was 15 with a degree in computer science. He's gone on to be a storied law professor, one of the most influential law professors of his generation, recognized as, I would say, the leading expert on First Amendment law, as well as maybe the leading expert on Second Amendment law. So Third Amendment better watch out because quartering soldiers will be his next project. But Eugene was born in Kiev. He immigrated here, then Soviet Union, now Ukraine, born in Kiev, and emigrated here when he was 7 years old. As already indicated, he was a sort of a computer science whiz when he was growing up, but then we were fortunate enough that rather than going into that world, he has joined us in the legal, in the law world, in the legal academy. He has been for many years, a distinguished professor at UCLA, where he's currently the Gary T. Schwartz Professor of Law. But as of the end of this semester, he is going to be taking up a position at the Hoover Institution, where he will be the Thomas M. Siebel Scholar in the at the Hoover Institution. One other thing I think is worth note is that Eugene has been one of the great innovators in blogging, and I was fortunate enough many years ago to be invited to join the Volokh conspiracy, which has kind of been hosted at different places. It's Reason now. I've not been blogging much in the last few years, but for many years I was very active. And Eugene really kind of revolutionized the Volokh conspiracy. In fact, the Volokh conspiracy has been so influential, an entire book was published which consisted of the debates on the Volokh conspiracy about the original Obamacare case when it went to the Supreme Court. And one of the things I think is very interesting is I think there was more debate on both sides, all the different sides of the original Obamacare case, just on the Volokh conspiracy than in all of the rest of the legal academy combined, which I think says something about the kind of sort of intellectual environment that's been cultivated on the Volokh conspiracy of respectful and engaged debate, even among those of us who participate in that. One final thing is, and we'll get to this in the question and answers, is Eugene is the counsel of record for a case that will be argued in the Supreme Court next week, the NRA versus Volokh case. He may talk about that in his remarks, but if not, we'll come back to it in his in the Q&A. He is of counsel for a few years now with Sher Jaffe, how do you say the first name? Sher Jaffe law firm, where he really specializes in high-profile First Amendment cases, among other things. Today, he will be addressing the idea of free speech law, civil rights, social progress, and minority groups. So he will probably speak for about 25 minutes or so. Then we'll open things up to questions, both from the floor here and if you're watching online, feel free to submit questions, and we'll be keeping track track of those. So we'll have time for Q&A when we're done. So it's a great thrill to welcome my dear friend Eugene Volokh here to CU Boulder.
Great, thank you very much for having me here. Thanks also to Mason and to the Voices for Liberty Project for helping put this on. They, among other things, they inspired me to put together this presentation. There are lots of other people working with the project who are doing similar talks all over. The premise of the project is that a lot of college students, starts off obviously out with high school students, college students, law students, have never really learned what I think when people of our age, Todd's and my age, went to law school, was much more familiar, which is that in many ways the civil rights movements of the last century were fueled by the freedom of speech, were made possible by the freedom of speech, and by judicial enforcement of free speech rights. These days, of course, there are plenty of conservatives and conservative causes and non-ideological causes that benefit from free speech protection, as there were at the outset as well. There's no doubt about that. And the court has repeatedly stressed that the free speech clause is not free speech for the left or free speech for the right. It's free speech equally for all. But it was especially important in many ways for the civil rights movements. And I think many people these days haven't really focused on that. So the purpose of this talk is to focus on it. Now, guessing at the age of the people in the audience, always a risky thing. To many of you, this may very well be old hat. But nonetheless, you know, it's the kind of old observations that are worth repeating and reminding people about. So let's begin at the beginning with the very first cases in which the Supreme Court struck down government action on freedom of expression grounds. They actually happened in 1931. It's a long time after 1791 for a variety of reasons. One of them was Gesundheit. One of those reasons is that the Bill of Rights wasn't applicable to the states, couldn't have been really applicable until 1868 with the 14th Amendment. And then it took until the 1920s for the court to conclude that it was applicable to the states. The free speech clause applicable to the states. It began with, actually in the late 1890s, with the takings clause, and then slowly the court began incorporating some of the Bill of Rights against the states. And at the time, the federal government wasn't doing a lot. It just was a lot smaller than it is now. And there weren't really a lot of speech restrictions imposed by the government, by the federal government, setting aside the Sedition Act of 1798, very controversial, but never came to the US Supreme Court, up until the Sedition Act of 1918. There were a few restrictions, chiefly having to do with a post office, which did come before the Supreme Court and were considered. But still, relatively few cases compared to the several a year that you see before the court nowadays having to do with the First Amendment. And also just the attitudes towards individual rights were somewhat more kind of friendly to traditional restrictions back then, and the law had not departed much from tradition back then. So the first cases were in 1931. One of them was Stromberg v. California, which struck down a ban on display of a red flag, which was essentially a display of red flag, more or less as sympathy for communism or at least extreme revolutionary socialism. So that's one of the cases. The other case was Neer v. Minnesota, striking down a scheme for injunctions against scandalous newspapers. So the first one really involved left-wing speech, and to the extent you focused on minority groups, well, Stromberg, it was Jetta Stromberg, actually a woman as it happens, although that I don't think was at all relevant, perhaps may have been more relevant that she was Jewish, because there was a lot of a left-wing radicalism among Jews. Maybe she was in part targeted because of that, although I'm not sure. In any case, Neer was an anti-Semite. His scandalous newspaper was in general alleging various kinds of corruption in Minnesota, but among other things, it alleged a variety of supposed Jewish conspiracies of gangsters and so on and so forth. It was not ambiguous stuff. And the court, in the same month, basically, recognized the rights of far left Jew to speak, and the right of I don't even know where you'd put him politically, of an anti-Semite to speak as well. So that's just a reminder of how ecumenical protection protection offered by the court has been. But then it was followed pretty shortly by a set of cases where the defendants were quite clearly members of, in that situation, racial or religious minority groups for speech that had to do with their sense of what they thought was important to promote the rights or the interests of their groups. So one of those cases were Herndon v. Lowry, also involved communists, but I will tell you, I have very little good to say about communists either in America or elsewhere. But one thing that they did do for I don't know, deep conviction, for tactical reasons, for whatever reasons, is they were generally quite sympathetic to civil rights at the time. So Angelo Herndon was a far left-wing activist, but I think it was also part of his sense of his agenda for black emancipation. In any case, one of the first decisions following the 1931 ones came in his case. Well, then there was Lovell v. Griffin, struck down a leafleter licensing scheme that was applied to limit Jehovah's Witnesses. Jehovah's Witnesses were seen as an extremist religious group, and they were. Actually, by today's standards, they might be viewed as hate speakers themselves. They were militantly anti-Catholic. I'm sure they would have been anti-gay too, although that issue was really not much in play at the time. But it was certainly seen at the time as a matter of civil rights that religious groups be able, including non-mainstream religious groups, be able to proselytize, just like Catholics could try to win converts, just like mainstream Protestants could try to win converts, Jehovah's Witnesses as well. And that was, again, an early case in which the court upheld free speech rights. Then following two cases, following three cases on the list also all involved Jehovah's Witnesses. There was a famous line from, I want to say, Harry Calvin, this is in the 60s, so you use 60s terminology, said if you had to explain the 3 decades, 40s, 50s, and 60s of free speech law, they were Jehovah's Witnesses, communists, and the Negro. That it was in the 60s, it was predominantly the black right, what today we would call the black rights movement, the civil rights movement, that was the primary beneficiary of free speech. The decade before, unevenly in some measure, but still on balance, communists, and the decade before, it was Jehovah's Witnesses. And by the way, these decisions end up benefiting a lot of other people as well. Again, it's important to realize that the court has tried very hard to say it's not like there's a left-wing body of left-wing free speech law and right-wing free speech law. It's the decisions that protect the rights of one group protect the rights of others as well. So for example, Lovell is one of the early cases that establishes that the government can't demand a discretionary license, or rather demand a license that would then be given in its discretion in order to leaflet. That maybe it could require licenses for certain things like a parade, but there it would have to be content neutral and non-discretionary in its actions. And for something like leafleting, it just had to leave people free to do that. Schneider was another leafleting case. Jehovah's Witnesses actually involved again, what today some might call hate speech. It was Jehovah's Witnesses going to a Catholic part of town and playing a recording that sharply, very harshly criticized the Catholic Church. Jehovah's Witnesses were part of a long-standing tradition among Protestants of sharply condemning Catholics, and of course there was a similar tradition in the opposite direction. But it was recognized by the court as an important part of people's ability to try to change other people's minds about religion, even in ways that others might find offensive and blasphemous. Finally, Barnett, of course, was the famous flag salute case, which is the foundation of many of the rights not to speak, rights not to salute, rights not to engage in various rituals. But it all began with Jehovah's Witnesses, who had a religious objection, in particular, to saluting the American flag. So that's kind of the quest for religious civil rights. The civil rights movement, as we generally know it, benefited from free speech a great deal as well. And one way of telling is just how many of the cases during that era had NAACP in their name. So NAACP v. Alabama held that Alabama couldn't try to uncover the membership lists, couldn't try to use coercive power to uncover the membership lists of the NAACP. Today it might be called the form of cancel culture. At the time, what it was is that Alabama recognized it couldn't just outlaw the NAACP, but figured next best thing would be to publicize the names of everybody who was a supporter for the NAACP and let social pressure, sometimes backed by risk of violence, but at the very least of ostracism, of loss of economic opportunity and such, do the rest. And the court said even when there's a content-neutral law, at least a facially content-neutral law that says all groups that do business, all corporations that do business in the state, including nonprofits, have to disclose their membership lists, that could not be applied in this kind of situation where it would interfere with the group's right of association. NAACP v. Button involved the protection of the right to solicit clients for pro bono litigation. Again, a general principle, but one that was particularly important to the NAACP because the NAACP at the time was one of the most prominent kind of political mission-based law firms, where they took cases not just to represent clients, but in order to accomplish a particular goal. That model of going out and soliciting clients was actually prohibited by the attorney regulatory rules of various states, and the court struck that down. NAACP v. Claiborne Hardware involved, speaking of cancel culture, involved a boycott by the NAACP of white-owned businesses in Claiborne County, Mississippi. It happened in the late 1960s, from 65 to 69. Tells us something about the slowness of the American litigation system, came to the Supreme Court in 1982. It's also an early doxing case, if you want to retrofit today's labels to the past. It's still, I think, the one that's most relevant when people talk about doxing or stochastic terrorism. Here's what happened. So the NAACP chapter wanted to conduct a boycott by blacks of white-owned businesses in Claiborne County, but not all black citizens wanted to boycott the white-owned stores. They wanted to shop at convenience stores, or they may just not have shared or may not have sympathized with either the goals of the boycott or the tactics or whatever else. So what happened was the NAACP stationed store watchers outside the stores, took down the names of all of the black citizens let's say black residents, who knew if they were citizens or not, mostly I'm sure they were, but black residents who refused to go along with the boycott, and then the names would be published. They would be mimeographed, this is pre-internet, and read out at meetings of the local chapter, which was the local black church. Unsurprisingly, some number, probably under a dozen, although the exact number was unclear, some number of the blacks who weren't complying were then attacked. Their shots were fired through the window, or they were beaten and the like. And the stores sued, saying this is tortious interference with business relations. You were using threats of ostracism and threats of violence in order to accomplish your goals and interfere with our business. And the court unanimously rejected that. The court concluded that threat of social ostracism is constitutionally protected, and even the presence of some amount of violence, so long as it wasn't expressly ratified by the organizers of the boycott, was not enough to strip it of protection. So again, another very important protection for the NAACP, which of course was facing the possibility that if it could be sued for this kind of thing, it could be sued into bankruptcy, especially by local hostile juries. But it wasn't just cases with the NAACP in their name that involved this. So for example, New York Times v. Sullivan involved a lawsuit against the New York Times, but it was a lawsuit against the New York Times for a libel lawsuit for an ad that was put out by civil rights leaders complaining about the actions of I think Montgomery, Alabama, police chief. Sullivan was a police chief there, and there was a verdict by, I think, an all-white, which was the only ones that were at the time, jury in Alabama at the time. I think it was like $850,000, which is a lot back then. And there was the prospect that northern newspapers who were covering the civil rights movement would face, again, either bankruptcy or face the need to stop their coverage for fear of that kind of liability. In this instance, it was based on an ad, but it could equally well have been based on news coverage as well. So that, too, was seen as an important protection for the civil rights movement. In fact, some modern critics of New York Times v. Sullivan argue that it went too far in protecting against libel, in part precisely because of the facts of the case and the sense that the libel system was being used as a political weapon against the civil rights movement. That if it weren't for those facts, then perhaps the court would have been more cautious in its rules. Who knows? And all of these decisions might have been wrong in some respect, but the important thing is that they were very important protections for civil rights movement. And there are others as well. Wood versus Georgia, Organization for Better Austin versus Keefe, Kerry v. Brown, all those cases, none of which, like New York Times v. Sullivan, none of which, actually, like all of these, none of their legal principles are, in civil rights cases, the following happens. All of them adopt broader principles, but all of them emerged out of the civil rights movement, and all of them involved the civil rights movement being protected by these principles that the court had developed. So that's First Amendment and civil rights. We talked a little bit as well about First Amendment and religious rights, the rights of minority religious groups to proselytize. What about First Amendment and gay rights? Well, there's not the same kind of Supreme Court case that deals with First Amendment and gay rights as prominently as the cases involving the NAACP, as obviously, I shouldn't say as prominently, as obviously. However, there were actually several important U.S. Supreme Court cases dealing with gay rights in the context of obscenity. Remember, today, obscenity, punishable obscenity, basically means extraordinarily hardcore porn. The war on porn is over and porn has won. It's possible that it's just that prosecutors don't bother. But I think even if when they do try to bother, if they ever get convictions, it's for something very, very hardcore. Well, that wasn't so back then. Back in the 50s and 60s, some of it involved, for example, non-illustrated material, just text. Some of the text must have had some degree of sexual component, but by today's standards would be seen as extremely tame. Unsurprisingly, material that had some gay component would be especially likely to be seen as appealing to the prurient interest. Remember, prurient interest is defined as a shameful or morbid interest in sex, as opposed to, and I'm quoting here from court cases, as opposed to a healthy, normal interest in sex. So while even depictions of kind of ordinary straight porn could have been and were often prosecuted as obscenity, for gay-related material, the bar was considerably lower, including just sort of textual discussions about the propriety of homosexuality. And in any event, in a couple of important cases, One Inc. versus Olison and Manual Enterprises Inc. versus Day, the court helped limit the use of obscenity law to clamp down on gay-related material. And that wasn't just the first, those are the Supreme Court cases. They weren't the first time the courts considered that, armed with the court's First Amendment jurisprudence. So one of the earliest cases was from New York court, low-level court, 1936, which involved an autobiography of a prominent novelist who had been gay. And I don't think the autobiography, well, I haven't read it because I'm a Philistine. But my understanding is that the autobiography was not particularly sexually explicit. But again, by the standards of the 1930s, any discussion of homosexuality might have been seen as obscene in the lay sense as well as in the legal sense. And cases like this helped allow that to be further, to nonetheless be distributed. Likewise, in the 1970s and 1980s, there were prominent cases of the circuit court level protecting gay rights groups at public universities and schools. And that was, I think, an important part of the gay rights movement, in part because that was a mechanism by which gay students were able to come out of the closet to each other, were able to organize for broader political purposes and the like. And that's not just me sort of summarizing the cases. I have just quotes from, I'm not going to read them all, but from four pretty prominent scholars of law and sexual orientation. Dale Carpenter, who's actually a co-blogger of Todd's and mine. He's a law professor, used to be a professor at Minnesota, now he's at SMU. William Eskridge at Yale. Carlos Bowles, Scott Skinner Thompson. All of them talked about how important the First Amendment was in the gay rights movement. So that's, I think a good illustration of just how more generally this is important for various minority rights movements. By the way, notice I've mentioned religion and rights of religious minorities, I mentioned race, I mentioned sexual orientation, haven't mentioned sex. There isn't the same kind of body of First Amendment law protecting women's rights movement, chiefly because I think well, for two related reasons. One is the first phases of the women's rights movement, which began in the 1800s, and actually the first great success had to do with the Married Women's Property Acts in the 1830s and 1840s, which began to emancipate women legally with regard to private rights. Of course, the suffrage movement took until, let's say, 1920. Is 20 the right? In any case, give or take a year. And there, that was really before the First Amendment came into its own before the court. So that phase of the movement didn't really require, may have required more protection, maybe would have benefited, but didn't have a chance to benefit from broad free speech protection. Now, of course, by the time of the women's rights movement in the 1960s and 1970s, there was the First Amendment doctrine was quite well established, but so was women's suffrage, and in a real way, and not in a way that had been denied the way it had been to blacks, especially in the South. So as a result, the women's rights movement mostly progressed through the political process. Women were half the voting population, and so as a result, I think that movement required political victories, but did not require the same amount of judicial protection as some of the movements of the true minority groups, which women, of course, literally are not, did not require. I could also mention, by the way, non-civil rights cases with black defendants, ones where unlike New York Times v. Sullivan, civil rights isn't even really a big part of the fact pattern. But still, maybe it's not an accident there were black defendants. Maybe they drew more attention in part because of that. And again, they were protected. Watts v. United States, that's the leading true threats case. Talley v. California, which was the first case that recognized the right to anonymous speech. Bond v. Floyd, which actually involved Julian Bond, who was a very prominent civil rights advocate. I think he was a Georgia legislator at the time, and the court recognized in that case rights of First Amendment rights of government officials, this is, I think, in part. All of what I'm talking about is in part because, again, minority groups are the ones who especially need First Amendment protections. It's unsurprising that some of the most important cases came when talking about the rights of minorities, because majority rights often don't need to go to the US Supreme Court. If it's really a majority, interest of a majority, it'll probably win in the political process. So there's no occasion for having to go to court to defend that, right? That's an oversimplification. You might have groups that are majorities at the national level, but minorities in particular areas. We see that sometimes with regard to some actions by universities and the like. But still, it's the minority groups that most need that kind of protection. And that's true both against overbroad restrictions and against selective enforcement. So that might relate to the cases on the past slide, that maybe even in the cases that don't seem to be civil rights cases, it may have been black defendants that were more likely to draw the attention of enforcers. And actually, in an opinion by Justice Thurgood Marshall, Grayned versus City of Rockford, the court notes the risk of arbitrary and discriminatory enforcement there as to vague laws. Similar risks have been raised about prior restraints, licensing schemes, and the like, and they're more broadly present in other situations as well. And again, just a reminder of why minority group members are particularly in need of free speech protection. More broadly, if you think about American social progress, for any definition of progress, I mean, your definition of progress may be different from my definition of progress, but for any definition of progress, pretty much all of it has largely been fueled by free speech, in part because that's what often it means. If you're talking about social progress, it's persuading people that some other way of doing things, it could be civil rights, it could be free trade, it could be economic liberty, it could be religious liberty, that's something that needs to change. That the existing rules are not sufficiently protective of it. You need to change it. Generally speaking, in America, the way we do that is through free speech. And since the 1930s, it's been strongly supported by judicial protection for free speech. There's a famous quote from U.S. v. Abrams. This is the opinion by Justice Oliver Wendell Holmes. And it's worth thinking a little bit about this. It's usually talked about as part of the marketplace of ideas notion of free speech. But it's useful to also think about how it plays out with regard to some of the issues we've discussed here. So the line is, when men have realized that time has upset many fighting faiths, they may come to believe that the best test of truth is the power of the thought to get itself accepted in the competition of the market. So people generally focus on the marketplace of ideas, but what does it mean, time has upset many fighting faiths? That wasn't a hypothetical notion to Holmes. It was very much a living idea, a living reality of the time. That as of 1919, the preceding century had seen a tremendous amount of change. Much of it was technological and commercial, but much of it was social as well, right? So look at the fighting faiths that he might have been thinking about. So it had been well established, for example, a century before, as a fighting faith, as the kind of thing that people would fight to defend, that women, of course, could not play a major role in political life of the country. By 1919, it was clear that women's suffrage would be enacted. Likewise, a century before, well, especially 2 centuries before, religious freedom was something that most people thought was a bad idea. And it was actually a very major innovation in America in many respects. America wasn't the only such place. I think Holland was pretty good on this too. But it was a huge step forward with the American Revolution to establish and then to improve religious liberty. Certainly Abrams, at the time of Abrams, Holmes was sitting on the court with a Jew, and apparently got along very well with him, Louis Brandeis, where 2 centuries before, or even a century before, that might have been something that people would have said, this is ridiculous. Of course, in the centuries since then, time has upset many other fighting faiths. For example, Holmes was not particularly progressive by the standards of what the label means today but on racial matters, right? And certainly at the time, much of the progressive movement of the time was actually more racist than the supposed conservatives that it was trying to dislodge. Woodrow Wilson was a classic instance of that, much more so than, say, Theodore Roosevelt. So at the time, the fighting faith probably would have been scientific racism. I think at the time, if anybody had said, well, what about homosexuality? Some people would say, well, what are you talking about? Holmes probably, as a man of the world, I'm sure he had heard a thing or two about this. Oscar Wilde, perhaps, was a prominent example. He would have been convicted of sodomy not long before. But I do think his view would probably, well, of course, it's some sort of mental derangement. I think transgender status, hard to even imagine people sort of accepting the views that today have been upset. Excuse me, it's hard to imagine people accepting the decisions that are broadly accepted today. Those are decisions where time has upset things from 100 years ago. Of course, the question is what of the orthodoxies that we accept today are going to be upset 100 years from now. But the Abrams dissent was very much a sense that just because we've always accepted a particular kind of understanding of a wide range of matters, including race, religion, sex, and so on and so forth, just because we've accepted it doesn't mean that we can be confident that it's accurate. So a few more things. One is, as I think I mentioned, the cases that we're talking about both often protected left and right using generally applicable principles, but also often relied on past cases from the other kind of political valence as support. So for example, that case NAACP v. Button that I mentioned, which struck down restrictions on the NAACP soliciting clients, it says, look, that the petitioner happens to be engaged in activities of expression on behalf of the rights of Negro children to equal opportunity is constitutionally irrelevant. Look, here are all these cases. Near, remember that was the anti-Semite. Terminiello was also an anti-Semite and a racist. Coons, also an anti-Semite. Those cases recognize the rights of those speakers. Well, we should certainly equally recognize the rights of those who seek racial equality as the ones who seek who argue for racial or ethnic inferiority. For the Constitution protects expression and association without regard to the race, creed, or political or religious affiliation of the members of the group which invokes its shield. So if the cases had come out the other way, if these cases come out against the protection for the racists, it seems much less likely that the court would have come out in favor of protection for civil rights as well. And of course, the court more broadly has talked about viewpoint neutrality as being an animating principle of the freedom of speech. There's an equality of status in the field of ideas. That was in a case that actually involved a civil rights protest. But Thomas v. Collins was a labor case, and the court said, look, we'd recognize the rights of employers to speak just a few years before. We have to recognize the rights of unions to speak the same way. So viewpoint neutrality is what allows dissenting groups, minority groups, to be better protected, precisely because it shows that the protection is available to everybody, is not just special pleading on behalf of a particular group. Now, to be sure, there's one prominent example of a case where the court reached a different result. By a 5-4 vote, I think the case is no longer good law in the sense its logic has been eroded by precedent after precedent since, but it's worth noting. Beauharnais v. Illinois in 1952 upheld a law that forbade as group libel a speech that portrays depravity, criminality, or lack of virtue of a class of citizens of any race, color, creed, or religion. And the logic of the law is, look, just as it may be libelous to accuse a particular individual of a crime, it could be libelous to accuse a racial or religious group of a crime. Now, it rested on the theory that First Amendment doesn't limit libel law, and that was rejected by New York Times v. Sullivan. And as I said, cases and commentators recognize it's inconsistent with modern First Amendment law. But one of the things that was noteworthy is that the dissent, I think I'm quoting here from Justice Douglas's dissent, highlighted the danger of this kind of law, which had been deployed against a anti-black racist, the danger of it for civil rights advocates. That the same kind of restriction that could be used against racists today could be used against anti-racists for denouncing lynch law in heated terms. And this wasn't just Justice Douglas's view. There was a friend of the court brief filed on behalf of the ACLU by Thurgood Marshall. Counsel for, this is a petition for rehearing, so he was now referring back to the Douglas opinion, share the fears of Mr. Justice Black and Mr. Justice Douglas that a weapon has now been given to enemies of minority groups. Okay, let me close with a couple of other points about kind of the modern debate. One thing that we often hear people talk about is recognizing a hate speech exception to the First Amendment, retreating from the rules of viewpoint neutrality that I'd mentioned. And returning, in a sense, to Beauharnais. Beauharnais may be seen as a proto-hate speech case. One of the problems is how broad and vague that term is. And that is something very much that the dissenters, for example, in Beauharnais talked about with regard to group libel as well. So, for example, arguments that transgender athletes shouldn't play on women's teams are often denounced as hate speech. Now, look, maybe those arguments are wrong. Maybe those arguments are immoral in some sense, but there are arguments that are held, depending on which poll you believe, probably by 2/3 of the population. In a democracy, you can't change those views unless you can confront those views, unless you can debate those views. And if they are made illegal, or more likely illegal on campus or on the internet or whatever else, or prohibited even by private entities on the internet, I think that's not going to really help argue with them, because it's just going to drive those discussions underground and will become much harder to find out who it is who has those views and then see how one can persuade them. Likewise, arguments to the Bible, Quran, Torah, etc., condemn homosexuality are already being used as basis for punishing people's religious expression. Arguments that certain religions are evil because they harm society or women or sexual minorities equally could be condemned as hate speech. Sharp condemnation of Israel. I put together the slide long before the October 7th attacks and the debates on campus afterwards, but certainly there are people who are now trying to suppress pro-Palestinian speech, both the extreme pro-Hamas speech and even less extreme speech on the grounds that it is hateful towards Jews. And I don't agree with actually that speech, but I do think that speech ought to be protected. Arguments about white privilege, white racism, and so on and so forth, or restricting immigration, legal or illegal, or arguments that abortion should be forbidden. Just one illustration, look at the UN definition. Any kind of communication that attacks or uses pejorative or discriminatory language with reference to a person or a group on the basis of who they are, in other words, based on religion, ethnicity, nationality, race, and any other identity factor. Well, again, arguments about white privilege, or that all whites are racist, or that whites bear moral responsibility for the actions of others who just happen to share their race, would be viewed as hate speech by the UN. Likewise, arguments that sharply condemn not just Jews, but Israelis, because that's a nationality, right, would be viewed as hate speech, as are arguments that would condemn Palestinians. The final thing is people say, well, what about Europe? Europe has various kinds of restrictions on supposed hate speech, and the skies haven't fallen. And I should acknowledge European countries, also some of the other Anglosphere countries, Canada, Australia, and such, they're democracies. They're free countries. I don't like their free speech rules, but let's not overstate the degree to which they're repressive. By the standards of much of the rest of the world, they're this far from the US. Nonetheless, you look at European free speech law, it genuinely is much less speech protective in many ways than American law. For example, under European free speech law, it's okay to ban blasphemy. Not just anti-religious hate speech, but just blasphemy in the sense of depiction of religious figures in ways that members of those religious groups find offensive. It's okay to ban personal insults against politicians. There's a prosecution recently about that in France happening, where somebody had sharply insulted Macron. There was a case in which a French court fined a leading historian for dissenting view as to the killing of Armenians by Ottomans during World War I. His view was this was not a deliberate genocide, but just sort of the hell of war. And yet there's plenty of prejudice in Europe as well as in the US. And it's not clear to me that any of those restrictions or any of the hate speech restrictions really do much to try to tamp that down. So with that, I close. I think Todd and I will probably have a bit of a conversation, and then maybe we have some questions.
Well, great. Thanks for that overview, Eugene. That was fascinating history. And a reminder to anybody who's viewing online, you can send in questions. So a couple of years ago, I was on a panel with Jonathan Rauch,
Yes.
who has done a lot of work on this, who's gay. And he made the observation that in the, in the modern age, what we have is the groups that have benefited in the past are the ones who are now most adamant in suppressing free speech. And he said it broke his heart that these mechanisms were used to generate gay rights, civil rights, and the like, that a lot of those people are the ones who've most turned against free speech. And I just wonder if you have any reflections on that, if you think that's accurate, if his concern is accurate, or what?
Well, so there's a line that I'd heard. And it's used about various things, but it's used about free speech. Free speech is like a bus. I take it when it takes me where I want to go, but then when I gets to my stop, I get off. And what I think is noteworthy about that is that's just human nature, right? It is human nature to use various principles as tools to accomplish your goals and try not to allow your enemies to use the same tools to accomplish their goals. And if you think your goals are just and their goals are not, it's perfectly understandable. In fact, under certain moral theories, it may be the right thing to do. You may want to allow your country to use weapons in order to defeat the enemy, but try to deny the same weapons to the enemy who's trying to defeat you. And you may be right, perfectly sensible in many situations. I do think in many ways, it represents a kind of a lack of imagination about how things might be, which is particularly inapt when it's how things were not so long ago. So just to give an example, I talk sometimes to people, and let's put it outside the identity politics. People, let's just say mostly people on the left who say, it's really important that the government be able to clamp down on misinformation about elections, misinformation about healthcare, and so on and so forth. And I understand the concern, because misinformation can really be quite damaging, quite harmful. Misinformation about healthcare could be deadly. Misinformation about elections can essentially make the elections be a poor measure of the actual popular will. But I ask them, okay, fine, so how would you like the Trump administration, the second Trump administration, to have the same rules? And they say, oh, no, we wouldn't want that. Well, how do you know it won't happen? Well, maybe a year or two ago, they'd say, well, obviously, Trump wouldn't get reelected. Okay, fine, but half the states, more than half the states, actually have people in power who have very different political views than you do. How would you like them to have the same kind of power? So likewise, I think it's very easy for a university professor who is at a solid blue university, as most universities are, or university students to sort of assume, yes, of course, my university is going to impose these rules, and they're going to be good rules, and yeah, it's fine. It's all to the good to have some of those rules be speech restrictions. And it's a failure of imagination to think, well, what happens if the legislature says, well, wait a minute, we run it, and we may not be as deep blue as you are? Mm-hmm. Or what happens if it's the legislature in some other state that imposes similar restrictions? So that's how I try to get this across to people. I don't always succeed.
Because it seems like sort of my observation about the university context is that people, that a lot of supporters of speech codes and the like just believe, I think with some empirical validity, that it is only applied in one direction. in many situations. Up until recently, one of the things I think is striking about the Israel-Hamas thing is it seems like it's now there's the principles are being applied equally, and all of a sudden a lot of people are finding religion to some extent. So.
Right. Well, there's the old line that a conservative is a liberal who's been mugged. Though, of course, liberals quite plausibly retorted that a liberal is a conservative who's been arrested.
Right.
And likewise, you might say that today's conservatives found free speech. It used to be, really, it was a liberal value by and large, however simplified. And there was mostly conservatives who were in favor of restricting it. Conservatives found free speech because they saw their speech being suppressed. And liberals, in some measure, lost, or maybe the new generation, lost affection for it because they found themselves in power, at least in certain places. And again, part of the problem is that's just human nature. The hope is, once you find it, you don't lose it again. Like maybe the liberal who's been mugged and the conservative who've been arrested, we'd hope come to a better understanding both of the need for police protection and the need for restraints on police power, let's say. And likewise, my hope is following the various incidents where there have been restrictions on what is coded as extreme left speech, which is basically pro-Hamas speech in this kind of situation. That I'm hoping that there will be now a new coalition of the left that's rediscovered speech and conservatives who want to protect speech. My fear is there is going to be a new coalition, and it's going to be of the conservatives who've rediscovered speech suppression and the liberals, or at least the left, who are also on board with it from their views from 5-10 years ago.
Right. I constantly hear people everywhere, right, especially laymen, who somehow or another it has gotten into the minds of, I think, probably a majority of Americans that the Constitution doesn't protect hate speech. What is your sense of where that idea came from? And so many people seem to believe that.
Right. Well, so I do think it was effective branding on the part of the academics who created the term hate speech. It's like, I guess, what's the phrase? It's a thing. Right. Like if you can persuade that people that hate speech is a thing, the inference they may draw is that it must be a legal thing, that it's not just a label that people use, but it sounds like commercial speech, campaign speech. It sounds like it may be a legal category.
Right.
And it's unsurprising. People say, well, all these Americans are civics illiterate or math illiterate. I remember somebody once said, I'll bet you a lot of plumbers complain that Americans are plumbing illiterate. Like something as important as plumbing, it's fundamental to our lives. How can we not know this? Well, the answer is none of us know everything or even many things. We usually know just the things that we study for perfectly understandable reasons. So I do think a lot of people don't really know what the legal categories are. And as a result, they hear something that sounds legally, that sounds First Amendment exception-y, and they just assume it must be so. But again, the question is how to fight it.
Yeah, because it strikes me the other thing is hate speech is bad and the Constitution is good. So, right? People believe the Constitution is good. So obviously the Constitution can't protect bad things.
Right, which may be sort of a flip side that sometimes people say, well, this is ridiculous law. Well, it must be unconstitutional. And I guess this is Scalia and Thomas that said, well, lots of things are, but many other justices before it as well. Justice Black said this about the contraceptive ban in Griswold v. Connecticut. It could be a stupid law, but it's a stupid but constitutional law. Right. Maybe I'm getting it wrong. Maybe it wasn't Black, maybe it was Stewart. In any event, so there is sort of the sense that the Constitution must forbid that which is bad, must allow the government action that's good. So maybe that's it.
In your talk, you talked about free speech. You didn't talk about coerced speech or compelled speech.
Right.
And one thing I know you've commented on in the past is universities requiring diversity statements as potentially a form of compelled speech, similar to loyalty oaths and the like. Would you elaborate on that and sort of explain what's going on?
So I briefly mentioned compelled speech, and I mentioned it briefly in part because it plays a role, but a relatively modest role in this story. It also plays a role, but a relatively modest role in free speech law generally, just because most cases involve speech restrictions, not speech compulsions. But one of them, remember the flag salute case, which many people who are members of ideological minority groups are particularly incensed at having to pledge allegiance to something that either they dislike, or I think the Jehovah's Witnesses would say it's not like we hate the flag or hate America, it's just that we cannot venerate it the way you're asking us to do because only God deserves that veneration. So certainly many ideological minorities, especially religious ones, because those are the ones who are often most devout, most devoted to their ideological beliefs, do find it particularly upsetting to say things that they think are wrong. It's also related, speaking of someone who is also a very religious man, Alexander Solzhenitsyn. He, in much of his, he was a quite devout, I think quite devout, let's say. Certainly by the standards of the Soviet Union, quite devout Russian Orthodox man, but of course also prominent anti-communist. His last essay before he left Russia, or excuse me, before he was expelled from Russia, was called "Live Not by the Lie." And he urged sort of a radical commitment. Radical means going to the roots, going to everything, not involving yourself in conveying things that you think are false. Says, I don't even insist that people start saying things that are true. Just stop saying things that are false. Stop participating in that. So this is actually quite similar, I think, to the views of many who don't want to create, let's say, same-sex photos of same-sex weddings or such. I just don't want to be a part of creating something that I think is false. So I think it's an important issue. It's an important civil rights issue in certain respects, again, especially for religious or ideological minorities. The way it plays out with universities is that many universities say, essentially, we want you to tell us about how you deal with diversity in your research, in your teaching, in your service, and so on and so forth. And some amount of that, setting aside for a moment the 14th Amendment questions about whether, having to do with whether they're seeking people who will discriminate based on race and hiring and so on and so forth, some amount of that may in fact be permissible because we are talking about government employment. And some amount of coerced or some amount of consideration of people's opinions may be relevant to that. So I suppose if you wanted to hire someone for the CIA, you might sort of try to probe them a little bit. Tell us a little bit about your history of sacrifice for your country, your history of being committed to the country's defense. And if we can see that this is something you've really cared about for a long time, then we're going to weigh that in your favor. Whereas if we see that you say, well, actually, I hate the country, but it's a fun job, you may have a different view, right? And if you just say, I'm not particularly interested in such things, I'm just a cryptographer, and I just want to break codes, then you might say, okay, fine, we might hire you, but maybe we'd prefer someone who's a cryptographer and a patriot, too. So you can imagine situations where you might want to consider that. And including in a university, you might say, look, this university, if we do have reason to think that it hasn't done a good job of educating Black or Hispanic students or some such, if you can show that you've thought hard about how to do that well, or have done some research on it, or have trained yourself, that might show that you're a more effective teacher. So there are some possible versions of the story that would not be constitutional violations. The example that I gave in a debate that I had, and I think this is a useful way of thinking about it, is what would we think about a situation where university said, not CIA, but a university said, we really value the sacrifice of our armed forces, especially in time of war. So, we'd like you to, when you list all of the things that you've written and all of the public service projects you've done, we'd like to particularly see which ones have had to do with national defense. That might be okay. Maybe one of the things we might consider. Maybe you haven't published as much because you have to spend a weekend every month for National Guard. But you'd start to suspect a little bit that maybe what they're looking for is people with a particular view about patriotism and about the military and so on and so forth, and not people with another view. And if it looks like that's what they're constantly asking of people, oh, tell us about your scholarship, or you're a historian, tell us about your focus on American military and how history could be used to make American military better. You might start to wonder if they're trying to create kind of an ideologically homogeneous faculty this way, in a way that we might think is not bad for the CIA, but not so good for the university.
I'll ask one more question. I'll throw it open to the floor. You talk a lot here about the government restrictions and that sort of thing. And this is what's going to be going on next week. It seems like government now understands the limits, and it seems like the formal limits, and it seems like what we are seeing and what the cases the Supreme Court is going to hear next week, the case you're involved in, NRA versus Volokh, Louisiana versus Murphy. These are cases sort of in the world of the regulatory state, right, where government is entangled with private power, where, I believe it was Judge Willett in the Louisiana versus Murphy case in the Fifth Circuit, where he basically said the government said, nice little social media company you got here, it'd be a shame if something were to happen to it. And they basically said, well, we're not telling you have to repress this speech, but, some people here, people in the White House are concerned about your monopoly position or these questions about consumer protection. And, I'm not saying they might go easy on you if you showed what good public citizens you are, but I'm not saying they might not go easy on you if you didn't show that you were playing by the rules. And of course, you can explain NRA versus Volokh better than I can. Why don't you just sort of, if you want to tell the audience a little bit about these cases and the questions they arise when you get out of these sort of core speech repressions to what seems to be going on now, which is this sort of soft power, arguably, that the government is using to control speech.
Right. So let me skip mostly NRA v. Volokh. It's the less interesting of the two cases. Interesting to me, but it's less interesting to others. And because I'm counsel of record in it, I can talk, it's not like I'm prohibited from talking about it, but I can't talk about it as kind of academically and dispassionately as I can about the others. So let's focus on Murphy v. Missouri. So Murphy v. Missouri has two components to it, two theories behind it. One was that the states of Missouri and Louisiana, and on behalf of their citizens and some other individuals, are saying, look, when the social media platforms restricted various kinds of speech, they did that in part because they were coerced by the government. The government, this is what you were describing, Todd, the government essentially threatened them, subtly threatened the platform, saying, you will want all sorts of things from us, right? Well, this is, could you see your way clear to helping, not even us out, but to doing the right thing as to restricting this kind of speech? There's a case called Bantam Books v. Sullivan, also from the 1960s. One of the good things about being a law professor is you get to see how these things have happened before. And you get to build a little mental test suite, to borrow a term from computers, for when somebody makes some suggestion about something, you ask, well, how would it play out there? So what happened in Bantam Books v. Sullivan is various government officials recognized that prosecuting people for obscenity was actually not that easy now that the courts had begun to crack down on obscenity law. So instead, there was this Rhode Island commission that would just send letters to booksellers that said, look, here's a list of all of the books we think that are obscene. And, we have the ear of police. We're not police ourselves, but, if you just remove them, everything will be fine. And of course, a lot of booksellers said, okay, fine, I'm not making much money from any one individual book. I'd rather just remove them than jeopardize my whole business. So the court said, well, that is impermissible coercion. So, but of course, it's always a factual question, right? Not everything the government says is coercive. There's always some degree of that, some tendency of that, but not enough to just mean the government can never ask for that anything be restricted. At least that any such request is coercive. So the one question is, where do you draw the line about coercive versus not coercive? But there's another dimension to Murphy, which is the most interesting. And that has to do with, what about things that are not coercive, but that do involve government encouragement of restricting speech? maybe even in the absence of coercion, when the government is deliberately trying to block speech, even through simply asking rather than demanding, maybe that's impermissible, because after all, the government is still trying to restrict the marketplace of ideas, right? So here's one complication. So there are two ways of thinking about this. One is, let's say that the New York Times is about to run an op-ed about, I don't know, some foreign policy matter. Someone at the State Department calls them up and says, look, you're the New York Times. I can't push you around. You know that. I know that you know that. So I'm not trying to make you do anything you don't want to do. But let me just tell you, if you run this op-ed, this will completely demolish our nuclear arms limitation treaty, or demolish any chance for peace in the Middle East. Can you see your way clear? Or maybe it'll disclose something that will lead, there's some leak that you're entitled to publish, but then it'll just totally destroy our diplomatic relationships. Can you see your way clear to remove that? I think very few people would say, and certainly very few judges, that's unconstitutional. Especially since, let's talk about misinformation. Imagine that the call to the New York Times is about just some factual thing, and it says, wait a minute, you're about to publish this op-ed, it's all bunk. I can prove to you it's bunk. Like, you're the New York Times, don't you want to publish things that are accurate? Don't your readers want to? Let me just tell you why. Look, you can publish it. You'll look like a fool if you do, and it'll be bad for the country as well. Again, you'd think that would be good. In fact, if anything, when a newspaper calls to fact check something, actually they rarely do, a magazine called to fact check something, the whole point is to prevent misinformation, right? So it can't be that all persuasion is just per se unconstitutional. So here's the other thing that sort of cuts the other way. I happen to own some rental property. And imagine that the police call me up and they say, Volokh, your tenant, we think, is committing some crimes. We don't have enough to get a warrant. But we know that under your lease, you can come on 24 hours notice and do an inspection. So why don't you ask for an inspection? And when you go there, look around. Don't even rummage through the drawers. Just look to see what's in plain view. Look to see what you're entitled to see. Well, it turns out many courts say that would be a government search. The very fact that the government didn't pressure me to do it, just asked me to do it, makes that government action subject to the Fourth Amendment. So that does cut in favor of First Amendment restraints. Very difficult question. I don't know quite how the court will resolve it, but it'll be argued Monday.
Do we have questions from the audience? Yeah. Is that Eric back there?
Yeah.
Let me repeat the question for those
please.
Online. The question was about Tornado Cash and a government action against them, and the larger question was about use of open source code and whether that implicates free speech.
Right. I'm inclined to be skeptical of the notion that the actual use of code is speech, or the distribution of object code is speech. Now, I do agree that if somebody wants to write an article for a computer science journal or for a web page and say, here's a piece of code, and here's what it does, and let me explain how it is, and let me guide you through the programming language. Use this as an example, let's say. Or it's not an illustration of the programming language, it's an illustration of some algorithm. I do think that is scientific speech. It's generally constitutionally protected. But my understanding is very few of these cases, in fact, perhaps none of these cases, well, actually maybe some earlier cases, but none of the recent cases, involve the government prosecuting or doing something else simply because someone has posted source code on the internet. That generally speaking, the theory is that it's kind of part of some automated tool where the source code is being constantly run, and if you submit certain data there, it's going to engage in some blockchain transaction and whatever else. That doesn't sound like speech to me. It's maybe communication, but it's not communication between humans. It is like you communicate to a machine and you cause it to do something. So one example that I give is imagine that there's code for a 3D printer. And let's say it designs for a gun. It's an interesting question whether designs for a gun, this is also being litigated right now, are protected, because they are actually human readable. Some of them look like just blueprints, and I do think engineering blueprints are protected. But if it is really something you can just plug into the 3D printer, imagine a 3D printer that's very small, quick, and portable. You just carry it on your belt. And instead of carrying a gun, you carry it and you carry some software. And then when you need a gun, you just push a button. It instantly prints the 3D gun for you. Sounds like could be a very useful tool. Interesting question whether it's protected by the Second Amendment. That does not seem to me to be a First Amendment question. If it is a First Amendment question, then everything is a First Amendment question. And why I don't think it's a First Amendment question is because this is not about people persuading each other or even people informing each other. It is about people using human readable material as input to a computer that actually does things and rather than just says things. That's my tentative thinking.
Just a quick question related to that, because it's required, I believe, by law in all states now that every program asks one question about AI. So it's a joke. I saw an interesting example. Everybody's obsessed with AI.
Yes, I know. I am too.
So this was an interesting thing I just saw this morning. It was a blog post about how Google Gemini libeled Ann Coulter.
Yes, I saw that.
Did you see this?
Yeah, this
article?
is by Bill Otis and Paul Mirengoff.
Exactly, Bill Otis and Paul Mirengoff. And what happened was they asked Google Gemini to tell them about Ann Coulter, the very provocative journalist. And first it refused to do it because it said she was such a bad person. Then it said it really wouldn't do it and spread it around. And then it just made stuff up about her.
Right.
How should we think about AI libel and how this relates to what you're
So this is a phenomenon that I dubbed large libel models. I actually wrote an article about this. I wrote the first draft in March of last year. Just when a few other people actually beat me to noticing it, but I just by accident kind of like, what's the first thing you do when you see an AI program? You ask it about yourself, right? You ask it about some other things. And I started making stuff up, and I realized some of it was fictional. Like I asked what American law professors have been accused of sexual harassment. And it gave me a list of 5. Two actually were real accusations. 3 were not. And it's not like they were falsely accused. No human being had ever, to the best of our knowledge, accused them of that. It's just the AI made it up, totally made it up. So I have an article on this very question that's out in the 3rd volume of the Journal of Free Speech Law. If you want to go to journaloffreespeechlaw.org, you can find that we have a whole symposium there on AI and liability. And I do think that under the right circumstances, there could be such liability. So one way of thinking about it is, if it's a public official who's suing, the rule, of course, is actual malice, but that doesn't require malice. The AI companies don't have malice. It requires knowledge of falsehood, more or less. So I think, and there's actually a case being litigated right now where this is the issue, if you are a government official and a program is outputting stuff about you, and you let the operators know this is false, and you prove it, it's not like he said, she said. It's like you said and it said, but no human ever said. There's no evidence that this is true. Then I think they have an obligation to stop it from generating these things. Think of it not as notice and takedown, but notice and blocking. Like they have to add code, obviously not a piece of code for each such request, but like there would be some code written that would look up on a database of known falsehoods that had been generated and prevent them from being generated again. What about negligence? Because in private figure cases, you can have negligence liability. And there I think the best analogy is defective product design. That just as you can sue Tesla for if it does have a self-driving car that hits someone, Not every time it hits someone, but if you can show that there was a safer alternative design that would have prevented that, I think something similar could be done as to defamation. But it's all in an article which is like 60 pages long, and I don't have the time, and you don't have the interest in having me go through all of it here.
Well, you're ahead of the curve. Dan?
So much. There's so much to ask, but I'll just add one question for you. I used to go around the block a lot with people like Fred Schauer,
Mm-hmm.
who made the point that he liked to answer the point that he made at the end of your talk, that freedom of speech is a bit of American exceptionalism.
Yeah.
He means that in a negative way.
Well, I'm not sure. I mean, he I think is open to other ways. I think he's suggesting that we should keep in mind that, you know, if the French do it a different way and the English do it a different way, maybe at least we should be open to that.
Very charitable. But I used to be taken aback by another argument that you just made, which you like to make, which is given the difference in liberal policies from the United States, surely no one should think that European democracies aren't free. And I used to think that was a much more powerful argument than I see now. So I'm wondering, since you've indicated some sympathy for that, whether these changed at all in the past few months,
No.
given that, for instance, let's take one case, I believe an Iranian, maybe citizen or maybe immigrant to England was just arrested for holding up a sign, a pro-Israel sign at a Palestinian, pro-Palestinian market. Was at what point do we get to say that actually, even if there were ways of implementing anti-hate speech laws that don't seem like they're saying make countries less than free, they nevertheless start as slippery slopes that we're sliding down to a place where we really ought to wonder whether this is a serious infringement on basic liberties of
Well, look, I guess my reservation is in saying, well, are they free or not free? And I think the answer is that freedom is a continuum. And at some point, you know, some things you might say this pretty clearly not. So if you don't actually have an opportunity to vote the bums out, because if you try to, you're going to get arrested. And as a practical matter, not that, well, some people might be arrested in various kinds of situations, but that you cannot actually have a movement to dislodge the person in charge. Russia, right? You can't vote Putin out. Maybe in some extremely unusual circumstances you would, but it wouldn't be an election at that point, it would be a revolution. You know, it may be that Mexico, up until some decades ago, which was basically a one-party state, may have been unfree, politically unfree as well, although maybe that had to do more with corruption than outright repression or whatever else. But, you know, Europeans, they have elections. They have people from the left and from the right running. Sometimes the elites get surprised, and it's good to sometimes do that, although not all surprises are good surprises, of course. So I think the real question isn't, are they not free? Yes, it's true they are free countries, but could they be freer? Could we be freer if we had fewer restrictions of some sort, or in a few situations, maybe more restrictions of some other sorts? So I do think that in a country where you are materially limited in your ability to debate immigration policy, that is a substantial intrusion into the country being free and democratic, right? If you're a country which you are substantially limited in your ability to criticize Israel, that's a substantial limitation in its ability to be free and democratic. But you know, America, for much of American history, had a lot fewer free speech protections than it does now. And I do think it was still basically a free country. It's just that I do think it's freer now. So my point is not that I like the European system. It's just I don't say, well, no, they don't have free speech. They do. They don't have as much of it as I think they ought to, but I do think it's important to recognize how much they have. And what they lack is, I think, a very small amount compared to how much they have, especially if we broaden the lens between our little differences across the Atlantic and look at the real differences between a Russia, which is, by the way, not the most tyrannical of countries, right? It's bad, but it's not that bad. It's not North Korea bad. But the difference between a Russia and England is vast. Between England and America is tiny.
Jerry?
Yes. Right. Right.
From a regulatory standpoint.
Let me just repeat the question. It has to do with, I think, paraphrasing, with NAACP versus Alabama, and obviously the idea there was the social pressure that could be imposed on people. And now, essentially, under either the sincere or insincere guise of campaign finance disclosure to make sure everybody knows who's influencing government, that is essentially being used now as a tool to weaponize the disclosure laws. And I think you may have been involved in some of the proposition battles in California.
Yeah, not directly, but I've certainly written about them. Look, I'm a big supporter of free speech. People sometimes ask me if I'm a free speech absolutist. Nobody's a free speech absolutist. Everybody thinks certain kinds of speech should be restricted. Threats of violence. Somebody goes up to you in a dark alley, says, your money or your life. They don't pull out a gun. So there's no conduct there. They don't actually take your money. There's no conduct there. All they're doing is speaking. Nobody thinks that that's constitutionally protected speech. Come up with other examples. Likewise, I think NAACP v. Alabama is a very important decision. And I think it's right, and it says essentially that the government, generally speaking, cannot require you to disclose group membership or donation to groups. We're in a free market economy. If you want your group to succeed, you have to be willing to put your money where your mouth is. Or sometimes put your money where your mouth is silent, but this is the way you do it. And I also think that it is important that people be able to spend their money in order to express their own views, but in particular, to pool their money with others, including candidates, in order to get them elected. At the same time, I think it's impossible to dismiss the worry about corruption. I mean, not just abstract corruption, but outright bribery corruption. And the flip side of corruption, which is extortion. So not just, oh, I'm going to give you $10,000, Todd, so when you become elected senator, you'll vote my way. It's that you come to me and say, Eugene, I know that you're really interested in having the right people be elected senator and be on your side, right? So, shouldn't you be donating $10,000 to me in order to have that happen? So both of those are really serious problems. And the conventional answer of those who would protect campaign finance is to say, well, we don't have to sharply limit, or perhaps even limit at all, expenditures and maybe not even contributions. And instead we'll have disclosure. That was, of course, a standard argument. Well, what about the argument that disclosure itself, mandatory disclosure, is unconstitutional because of these reasons? And I do think the mandatory disclosure is potentially quite dangerous. It does create a risk of social ostracism, it creates a risk of economic retaliation, creates a risk of government harassment. At the same time, the flip side creates a risk, which is also bad for democracy, right? Restricting speech and political activity is bad for democracy, but bribery and extortion are bad for democracy too. And it probably is the case that knowing who is donating, especially the really large sums of money, is something of a clue that would help people figure out whether those kinds of corruptions are in play. So that's why it's hard for me to say, nope, non-disclosure, right of confidential association for contributions all the way. You want to donate $1 million to a candidate for office. You can do that, and neither of you has to disclose a thing. I'm not sure that's right. In fact, I suspect it's not right, even though I do see that requiring such disclosure or capping the contributions may interfere with speech as well. Right. 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 So
the follow-up questions about donations to nonprofit organizations, not just politics.
Right. So one problem is, if you want to donate to a tax-exempt group, you can't just say, IRS, I'm going to donate $50,000 to this tax-exempt group, and I want to deduct this $50,000. But yeah, trust me, but I'm not going to tell you whom it is I'm donating it to. Maybe it's my son, right? So in that kind of situation, there has to be some degree of disclosure under certain circumstances to the taxing authorities. Now, generally speaking, they are under obligation to keep that confidential, unlike the campaign contribution, which is supposed to be publicized. Of course, any such obligation can be violated. But again, if there's no way for them to figure that out, then I just don't see how we can maintain charitable tax exemption, given that would then, by hypothesis, be absolutely no constitutional way of catching anybody in a lie about a charitable tax exemption.
I think we got time for one more question. Trent?
Yes.
Are these situations
Oh.
So the question was about, and what he thought you said was the difference between veterans' benefits, which may be earned versus racial.
Right. Yeah. So just to be clear, I wasn't talking about veterans' preferences in admissions, let's say, versus racial preferences in admissions. Those raise interesting non-First Amendment questions. Mostly 14th Amendment, it is presumptively unconstitutional to discriminate based on race in admissions in public universities or under Title VI in private universities. It is not unconstitutional to do that based on veteran status. I was rather talking about an analog to the DEI statements. So there it seems to me that the analogy has to do with academic freedom of the university. It may very well be that veterans do great things. But if what the university is trying to do is trying to find faculty members who are pro-military.
Or pro-patriotic.
Or pro-patriotic, who have that set of views, that is, I think, an interference with academic freedom. Because what it essentially says is, if you have the wrong views, we're not going to hire you as a faculty member. On the other, and likewise, if it's trying to have people have the right views about race or the right views about wide range of other things. So you know, veterans have done tremendously good things, but I don't think that faculty members who support veterans should be given any preference over faculty members who don't support veterans.
So I guess the question is,
that is a very good question.
The question is, what is the best way to maintain academic
That could be a whole other panel.
And so that ends this conversation, and I guess starts a new conversation for next time you're here. So I want to thank Eugene for being here. I want to thank the Voices for Liberty Project at the George Mason Law and Liberty Center, and of course the Benson Center. So thank you all for being here, and thank you, Eugene.
Thank you.